Well, let me say we don't see this as a conflict, but we see it as a development of our democracy and as a process through which we begin to understand our delineated roles in the education space as various role players.
And Felicity Coughlin, your point of view on this?
I must say I agree with that. If that is the manner in which these cases are being undertaken, one has to question, though, whether it is. The reality is that education is meant to be about the rights of the child, protected in the Constitution and in every moral framework that any of us share. And if conflicts are about protecting those interests through working out who has which role and which power, then it has to be good for democracy, but most importantly,
why do you say,
good for
although
children?
one does wonder if this about the manner in which they're being undertaken, the legal cases?
I'm concerned that in resolving things in the best interests of children, it's necessary to move all the way to the Constitutional Court before agreement can be reached between stakeholders who should be sharing the best interests of the children.
Mm-hmm. And Mr. Mwedi, this is what I wanted to come back to you on and raise this issue, that if it's a function of our democracy, which is something that should be upwarded, evolution, maturing of our democracy, but the Schools Act and the Constitution are very clear about the laws in terms of education. It assigns very clearly, from at least from what I read, perhaps there's questions on that, the roles of both schools and the government in rolling out the laws. So why do we end up having issues that are in these laws ending up in court?
Well, they might be clear in the letter, but there might be complications in terms of application. The letter and the application are two different things. And I think I agree with the colleague. In all instances where the department intervened, it was in the best interest of the child. And of course, our responsibility is to ensure that whatever we do is in the best interest of the child.
For instance, are you clear as to whose responsibility it is to determine capacity on the issue of admission in schools, Mr. Mweli?
Well, we're very clear in terms of the roles that are delineated. Well, in terms of the policies that regulate that, it's the responsibility of the STB. In terms of capacity for admission, is the role of the HOD. And in terms of Section 16 of the South African Schools Act, that role is carried out by the principal as the day-to-day accounting officer of the school.
Dr. Deacon, your thoughts on this?
Well, I disagree with Mr. Mweli on the last answer. We'll have to wait for the constitutional ruling in the Rivonia case to get a clear answer on that, but we're on two different pages. The capacity of a school and the whole admissions process. Our experience is that the department simply hijacked the process and gave contrary instructions to the school principals and abusing Section 16A to put pressure on school principals to follow instructions, illegal instructions from the provincial department. So that matter is now in front of the Constitutional Court in the so-called Rivonia matter, and hopefully we'll get judgment soon, and that will give us clear guidelines on how to deal with this in the future.
So you would disagree with the Schools Act, for instance, that SGBs in determining things such as admissions have to be subject to provincial law?
Well, we should distinguish now between laws and policies and simple instructions from HODs and from officials.
Okay.
Obviously, governing bodies must comply with the Constitution. They must comply with legislation, provincial as well as national, but so do officials, and that's our problem. I don't think we should only debate what's the best interest of the learners and then trample on legislation. All parties must comply with legislation in fulfilling our constitutional obligation and our duty towards the learners. And that's exactly our frustration, where the departments and specifically officials in the individual capacity sometimes abuse their power. We've got a very good relationship on a national level. We frequently meet with Mr. Mweli and his colleagues in the national department. But our problem is on grassroots level with the officials closest to the schools.
And when you say officials closest to the schools, can you please just give us a sense of at what level?
That would be your district directors and officials in the district offices, giving direct and conflicting instructions to principals and threaten them if they don't comply with the instructions, that they will simply take disciplinary action.
And what is your experience, Ms. Cochran?
My sense is that the school governing bodies are a very important part of what it is that we're trying to achieve in a partnership relationship with education. So I must agree with your previous guest that the relationships that surround a particular school are the ones that have the major impact. And as long as the school governing body is working within the Constitution, and it is important then that there is a good, strong relationship of respect between the local authorities and the school. Otherwise, we'll end up in a situation where an already overburdened system is expected to then run a school. And the whole purpose of the way we do things is that that shouldn't be happening.
Mr. Mweli, if you just look at the whole pregnancy case outcome, what was found was that the HOD acted in contravention of the School Act. So basically, it was interpreted that the HOD was asking the school to go against national policy. And if we're looking at delineation of powers, what is important for us to understand as the public, do officials who are employed in these positions know the various laws, the Constitution, the Schools Act, for instance, and do they know what roles they play, whether or not they are able to issue instructions and the powers of school governing bodies, for instance?
Thank you very much, Sepiso, and I'm very happy that you brought this case in. Let me indicate that we are in a process of studying the outcome of that case. We'll comprehensively respond to the judgment. But let me also say that the flagrant violation of South African laws and the Constitution has been acutely prevalent in cases that school governing bodies have been involved in, including this one of the Free State. Two things that we are reading out of this case. The first one, I agree with you. The outcome says the HOD does not have the authority in law to instruct the principal to ignore policies of the SGB, which we agree with, right? The second issue is that the judgment has found the policies of the governing body in question to be completely inconsistent with the Constitution of the country, with the laws promoting equity in this country. And what are we saying about that as school governing bodies? Now, for us, access is a fundamental issue because we're dealing with education, especially when it applies to girl learners. We know internationally what has been the occurrence in terms of, girl learners who are supposed to be in school who are not in school, including in SADC. And South Africa is doing fairly well so far in terms of affording access to girl learners. Anything that seeks to undermine those efforts will definitely intervene. The intention of the HOD was well placed. The only issue that the judgment is saying is that he doesn't have the authority in law to instruct the principal not to implement policies of the SGB. Not that he doesn't have the authority to give instructions to the principal. That's not what the judgment is saying.
Proper procedure would have been that the HOD should have written to the school governing body and registered his concern. Is that not correct?
That's correct.
Was
That's
that
correct.
done in
fact,
this case?
The outcome is saying you're addressing the issue with the wrong role player. The right role player is the school governing body.
But to your knowledge, was this done in this case?
Well, I wouldn't say, Tsepiso. I don't have all the facts before me at the moment. But as I said, our view is that the intention of the HOD was well placed. Is the ultimate point of appeal in the administration. He had to do something to make sure that access is afforded to this learner.
You talk about flagrant flouting of constitutional law by SGBs. We've just mentioned the Free State one. Are there any other examples that you would like to note?
There are many. As a former HOD in the Northwest, I dealt with many of such. You remember the Vryburg case, Vryburg High School case, the girls' high school. There are many of them. And as an official in the basic Department of Education, we're virtually dealing with many.
Are you able to categorize them for us? Did they include admissions, language, religion, etc.? Just because I want us to really delve into this, why there are these conflicts, these court cases, when, as I mentioned, there are laws that stipulate what should be done in certain instances. Why is there a difference of opinion?
Indeed, there are various categories of those. One relate to admission and admission policies. The other category would relate to the language policy, and the others would relate to issues of the medium of instruction, of course, which will relate to the issue of the language policy. The main big ones are around admission and the language policy, and some are related to the policy that relates to religious observance.
Dr. Deacon, would you like to respond just before we take a break?
Yeah, I think two things about the pregnancy matter. Those schools followed guidelines issued by the National Minister of Education, the then Minister Naledi Pandor. So they didn't compile their own, they used the guidelines. So it was issued by the National Minister. But number two, I think that's the crucial aspect. You asked the question, did the HOD engage with the SGBs? In the court papers, and I was involved in that matter from the very beginning, the SGBs wrote 3 letters to the HOD to request, let's meet, let's have a discussion. In a third meeting, FETSAS intervened to call the meeting, but it was ignored by the HOD. Our concern is not necessarily that we don't follow the letter of the law, but the fact that parties don't engage in a meaningful way before we approach the court. In every instance, every governing body who took a matter to court, that was the last resort. So our advice to our members would be we won't go to court if we haven't exhausted all the other remedies available. So that's a last resort case. And in most of the instances, we either don't get an acknowledgement of a receipt from a letter, or the department don't show up at the meeting, or they simply say we're not going to meet with you. That's the instruction. It's final. In that attitude, that's not really helping education at all.
Anonymous in Cape Town, I believe you've called back. If I could ask you to please be brief.
I'm Anonymous calling from Cape Town. I think the department should be allowed or should be given authority to interfere with some of the decisions of school governing bodies. I found myself in a position now where I've applied for admissions to a school in the Tokai area in Cape Town, but I'm being prejudiced because I'm not living in the area. So what they actually say is I should first be able to afford a house of 4 million rand before I can send my daughter to a school where she's able to access good education. So I find myself in a position where I'm prejudiced. As the previous caller,
Anonymous, you said which area is this again?
I'm applying in the greater Tokai area, and I live in one of the suburbs in Tokai. And I can't send my daughter to a school in the Tokai area because I live in a suburb in retreat. And I find myself being prejudiced, and I think it's a form of apartheid to exclude people from good schools in the area just because they don't live in the...
Are you able to tell us the name of the school, Anonymous?
No, I don't want to. I don't necessarily, but I am busy dealing with the department on it. And if I don't have any joy, I would like you to take my contact details so that the DG there or the person representing the school governing body can give me a call, because this is a matter that I actually want to take forward.
We'll get a response from our guests on in just a moment. Just to continue with the conversation, the issue was raised about language policy and admissions, and I'd really like to look at Anonymous's complaint about his attempts in trying to enroll his daughter in a school in the Greater Tokai area, but because he lives in retreat, he says he's been discriminated against. Now, SGBs are responsible for admissions policies as well, in line with the Constitution, though. The law is very clear on that. So, Mr. Mweli, in this case, this kind of thing has come up against, we come through the course, we're talking about the Ravoni issue as well. What do you say to schools in knowing that this is how far your responsibility goes, that you can't go beyond this, and that is obviously going against the Constitution?
Well, Tapiso, my understanding of the matter raised by the anonymous caller from Cape Town is that he is still taking up the matter. And my understanding is that he might get help. In case he doesn't get help, he has requested that he be put through the right people. But let me indicate that a province like the Western Cape doesn't have a zoning policy. It's first come, first served. So, and I think what we also need to understand is that whilst we acknowledge and appreciate that the admission policy becomes the basis of carrying out admission in a school, the admission is done by the principal, not the school governing body.